Welcome. My name's Hugh McDonald. I'm the Principal Researcher at Victoria Law Foundation. It's my pleasure to MC this session. It's the penultimate session of our International Access to Justice online forum, which has been convened by the University of California, Irvine Law School's Civil Justice Research Initiative and Victoria Law Foundation. In this session, we're examining the role of legal education and access to justice. Thank you for joining us. It's my privilege to acknowledge the traditional custodians of country wherever you may be joining us today, and to recognise their abiding connection to the land, its waterways and community. The Office of Victoria Law Foundation and my home is on the traditional lands of the Wurundjeri people of the Kulin Nation, and I pay my respects to their elders and to all generations of Wurundjeri and other First Nations people, their elders joining us. I thank them for their custodianship and acknowledge that the lands I am on were never ceded. I'll just quickly run through some housekeeping. If you've joined us before, you will have heard this. Only panelists can be seen and heard. All attendees' videos are turned off and their audio is muted. Please use the Q&A function to ask questions, to see the questions that others are asking, and to upvote the ones that you're interested in, if you so choose. We're recording the session and it will be distributed later. Towards the end of the session, we'll post a link to the final forum session where there'll be an all-star panel, which will be tasked with looking to the future of access to justice. That link is also in the program, and it's available on the Foundation website. It's my pleasure to introduce the stellar lineup we have for this session. We're joined by Anna Carpenter, who's a Professor of Law at the University of Utah's S.J. Quinney College of Law, by Louisa Gibbs, who's the Chief Executive Officer of the Federation of Community Legal Centres Victoria, by Jeff Giddings, who's Professor and Associate Dean in the Law Faculty at Monash University, and by Katie Young, who's the Assistant Professor of Sociology at the University of Massachusetts. Our facilitator is Melissa Caston. Melissa is Director of the Caston Centre for Human Rights Law. She's Associate Dean in the Law Faculty at Monash, and we're privileged to have Melissa as a member of our board at Victoria Law Foundation. So over to you, Melissa.
Thank you very much, Hugh, and thank you for your acknowledgement of country as well. It's my privilege to introduce to you in a little bit more detail our speakers today. So I hope they're all appearing to you as I can see them. I'm just going to do a quick whip around the call and just give you a little bit more information about each of our speakers, and then ask them to talk a little bit about their work in this domain. So I'll start with Professor Jeff Giddings, who's the Associate Dean Experimental Education and a Professor of Law at Monash University. And in this role, Jeff has conduct of Monash's Clinical Guarantee and the Monash Clinics program. I thoroughly commend to you his book, which is called Promoting Justice Through Clinical Education by Justice Press. It's particularly apt on this topic that we're talking about today. Anna Carpenter is a law professor and serves in the Office of the President of the University of Utah, where she provides leadership in higher education innovation. But her scholarship in law includes empirical and theoretical work on civil courts and judges, access to justice, the relationship between law and courts, and structural inequality. And she also writes, of course, on legal education and clinical pedagogy. And she's the founder and director of Justice Lab, a clinical course where students work with community organisations to solve legal and policy problems and advocate for systemic change. Catherine Young is an assistant professor of sociology at the University of Massachusetts and also an associate editor of the Law and Society Review. She also works as an adjunct law professor. And Katie investigates how people think about and interact with the law and the effect of these patterns on distributive justice and people's ability to solve their problems. Her work on the relationship between access to justice and legal consciousness goes to the core tensions and themes in the relationship between social sciences and the law. And Louisa Gibbs is the Chief Executive Officer at the Federation of Community Legal Centres, leading Victorian peak body for community legal centres. And that body is part of a very powerful movement for social change, reshaping how people have reshaping how people access justice. The Federation has some very interesting new research undertaken with the Victorian Law Foundation, and that helps us better understand the specifics of the community legal assistance sector and its workforce. And Louisa will talk to us about some of the legal education aspects of that new research. So I'm going to now stop talking that quickly and turn to each of our panelists today and ask them to tell us a little bit about how their work intersects between the access of justice domain and the relationship with legal education, whether that's within the law school or even beyond. So I wonder, Jeff, if I can turn to you first and ask you to describe a little bit of the work that you're doing in this area.
Thanks very much, Melissa. I really appreciate the opportunity to speak with you all. My work is really around the operation of the Monash Clinical Legal Education Program. First in Australia, started in 1975, the largest in the country and one that I feel proud of, being having the opportunity to be a custodian. It seems to me that legal education can make a very significant contribution to access to justice if you have a clear vision as to what you're seeking to achieve, and you develop the scale in order to make that happen. And so if I can just talk briefly about the work at Monash. I've been involved in this firstly as a student when I was at Monash, then as a researcher, and now as the Associate Dean, who is the custodian for the program. Our clinics have a strong tradition of what I would describe as community law with a major focus on family law. Over the past 4 years, we've very significantly expanded the reach of the program and the range of areas of law that we're working in. So we've introduced a clinical guarantee, which means that every student who commences in any of our combined degrees or the standalone law degrees is guaranteed the opportunity to participate in the clinical program. What that's meant is that we've gone from, in 2017, there were some 200 students involved. Last year, despite COVID, we had over 760 student places. So we've dramatically increased the reach. In terms of areas of law, we've moved from that traditional community law base to introduce a range of specialist clinics in new areas, and I would characterise those as relating to either human rights or to climate justice or to international trade or to commercial type law in terms of innovation and startups and those sorts of areas. We're introducing a tax clinic this year. So there's been a very significant growth in what we do, strong foundations in that community law domain, which we are now using that expertise and experience to enable us to work with a broader group of clients and beneficiaries in relation to the work that we do. we can't do that without effective partnering with a wide range of organisations, including, and very importantly, community legal centres, but also with a range of other organisations, from government to private law firms, who are often supporting our clinics in a range of ways. So that's the picture. To me, it's about, yes, we can make that contribution. What we need is the vision and then the scale to have that impact.
Thanks very much, Jeff. That makes the connection between the relationship between the law school and the access to justice area very, very transparent. And I think it's been a feature of Monash for a long time. It's expanded dramatically recently, but it has been an enduring feature. Anna, can you give us a little bit of background about the work you've been doing in this area?
Sure. So in the United States, there's a growing recognition, particularly in the past 5 years, of the nature and the extent and the seriousness of what many call the access to justice crisis. And I've been involved in that work as a researcher, as a teacher, and as a sort of advocate for change. And I'll just name a couple of observations that I take away from that when it comes to legal education. So given in America right now, we are at a fulcrum point of change. So within the last couple of years, we've seen Utah and Arizona make massive changes in the rules that govern the practice of law in those states, and many other states are considering similar changes. One example of that is that Utah has a sandbox, a regulatory and experimental regulatory space where new types of providers of legal services can provide legal services in new ways, whether those new ways involve human beings or technology. So we've created this space where we can experiment and figure out ways to involve, to help to solve people's legal problems without simply relying on lawyers who have been, sworn in to the bar. And one of the things that's notable about this movement towards regulatory reform that's really sort of sweeping across the country is that we've seen very little, I would argue, relatively little engagement or interest from American law schools. And I firmly believe that law school deans and faculty need to play a bigger role in shaping the future, and they can, right? If law schools come to the table in these reg reform conversations, they can be part of shaping what the future looks like. So we sort of face a landscape of risk if we don't engage, and I would argue opportunity if we do. And I'll name sort of a handful of things I think we could be doing. So one, using our research function, right? Regulatory change means developing new models of providing legal services, and those models need to be evaluated and evaluated well, right? Law faculty can do that work. When it comes to our teaching function, we need to be building the bench in our JD programs, and that includes teaching about access to justice and civil procedure courses, teaching about regulatory change in our professional ethics courses, training our students, teaching them how to create new legal services delivery models, right? How to actually create new programming, how to be entrepreneurial and innovative and be program developers. Another important piece is training our JDs how to work with people who aren't JDs and aren't lawyers, to do interdisciplinary collaboration, because that's really the spirit of what's possible in the reg reform spaces. And then the other, and I think this is really critical, and we aren't seeing a lot of engagement on this front, is law schools building the bench for allied professionals who are not lawyers, in terms of actually creating the training programs that are going to prepare those folks to provide legal services and to do so in a really high quality way. So those are kind of the opportunities that I see ahead, and I'll close there.
Thanks, Anna. I really appreciate your mention of that interdisciplinary path and the idea of going beyond, everything being about law and lawyers. Because obviously from the other point, no, people don't see law and lawyers as the core of their existence unless you are actually a lawyer or a law school. Katie, can I turn to you now, and can you tell us a little bit about how your work fits in this space?
Sure. Thank you. And also thanks to Emily and Nigel for bringing us all together for this really amazing event. I actually used to see my work on legal education as separate from my work on access to civil justice, which I came to more recently. And I've since realized how intertwined these realms are and how, at least in US law schools, they're both marginalized areas of work within the academy. I've written a bit about how the access to justice crisis should prompt changes in legal education and why law school is kind of misaligned with access to justice goals. And I thought I would start by kind of pointing to three sources of misalignment. And I think you're going to see some resonance with Anna's comments as well. And I've touched on two of these in my past work quite a bit. First, at least in US law schools, law students are taught almost nothing about the larger legal ecosystem, right? They do not learn, at least as part of the standard law school curriculum, about the frequency of self-representation, or about allied professionals of various stripes, or about the evolution of a legal problem from start to finish. And they do not learn about who experiences which problems and who takes the problems to lawyers. That is, we are taught implicitly and explicitly to view legal problems in isolation, right? To distinguish legal problems, their province, from problems that are not technically legal problems, right? And thus not their province. And this kind of training is why so many of us, I'm sure, have sat in meetings with groups of judges or attorneys very committed to access to justice and unable to get them to disentangle access to justice from access to law. Lawyers are not taught in law school to think of themselves as a small part of a vast problem-solving web that needs to be connected to other parts of the web to help as many people as possible, right? We teach them to think more myopically. Second, the bar exam passage confers omnicompetence on lawyers, right? You can write a will, defend a bank robber, file an employment discrimination suit, right? Any of these things. Before you pass the bar, you can't do any of them. After you pass the bar, you can do everything. Short of committing malpractice, right? The sky's sort of the limit. But of course, you don't really know everything, and you don't really know everything, but you've devoted an ungodly amount of time and money to have this omnicompetence conferred. So from a social psychological perspective, this is bad. It creates cognitive dissonance and a need to justify the system and kind of defend oneself against the suggestion, not altogether wrong, that the emperor has fewer clothes than you might have been led to believe. It's precisely the kind of system, right? Expenditure, difficulty, and mental health sacrifice that you'd create if you wanted to make people not open to their expertise being challenged or questioned, and not open to having subsections of it parceled out to others who have maybe a more circumscribed area of training and might be able to do things faster or cheaper in certain realms. And this, of course, relates to the ecosystem problem. Three is maybe something we can't do a whole lot about. And that's that, law school was not conceived to create access to justice. It was conceived to create lawyers. And that's just what it does, right? During law school, it becomes glaringly obvious to students who thought they were in the justice business that in fact they're in the law business. And from there, a few things can happen. And in one of the studies I'm doing now, I'm following 53 law students at 35, I think, different law schools longitudinally over 3 years. They're second years now. And I'm watching these things happen. So these students are wonderful. They're great people. They like justice, right? They would also like enough money and prestige to justify the sacrifices they're making. And this motivates them to convince themselves that the system is not so bad, that by being simply part of the system, they're kind of contributing to justice. And we don't really teach them otherwise or lead them to challenge this, right? I mean, for the most part, we don't teach about the kind of ultimate futility of law firm pro bono work to achieve system-wide change in the access to justice realm. We don't teach them the research that shows that sometimes it doesn't matter if you have a lawyer, sometimes it matters. And worst of all, I think at the highest prestige schools, at least again in the US, we capitalize on their risk aversion by kind of dangling law firms in front of them, law firm jobs in front of them, literally before they even start their 2L year. So they're, a third of the way through law school, and these smart, risk-averse people can have a job locked up, right, and consider themselves successful. And this teaches them that the last 2/3 of law school and how they spend it is kind of irrelevant to their work lives. So some of them come in wanting to fight for justice, but if they didn't, law school certainly isn't going to create the impetus, and it might even make it go away. I'll stop there.
I wanted to say don't stop, but you've stopped. But Katie, thank you. That was fabulously provocative for me. So I just feel like I have to park all of that you just loaded up into my brain and just turn to Louisa for a few minutes and give her a chance, and then we'll come back round to follow up on some of those threads. Louisa, can you talk to us a little bit about that new research that's emerging and how that intersects with the role of the Federation and its mission, really?
Yeah, thank you, Melissa. Thank you, everyone, for having me here today. And I'd like to acknowledge that I'm also calling from Wurundjeri land, and I pay my respects to any First Nations people who are on the call. I just thought maybe I might give you a little bit of an overview of what community legal centres are, because there might be some of you on the call who aren't familiar with them. And I'm very proud to say that Victorians were the early movers and shakers of this community-led movement to provide free legal advice and services that reach far beyond what any government legal aid commission is able to do. So around 50 years ago, a number of murmurings were happening, and this included a group of Monash University law students and academics who started a small phone line clinic. It also included people opening up a free nighttime service in the bottom of the Fitzroy Town Hall, and at that time Fitzroy was one of the poorest suburbs in Melbourne. And it also included the formation of a community controlled cooperative society called the Victorian Aboriginal Legal Service that strives to provide quality and culturally appropriate referrals, advice and representation for Victorians who are Aboriginal. So now, from those early beginnings 50 years ago, we now have 46 community legal centres throughout Victoria. And this includes 21 place-based services which understand intimately and respond to the needs of their specific geographical communities. But it also includes 25 specialist services that deal with an array of legal needs, from tenancy to employment, social security, or for different communities such as asylum seekers, recent migrants, women, people living with disabilities, young people, seniors, or even topics, so environmental law or animal rights. Now, community legal centres seek to bring legal services to wherever people need them, and they operate in an integrated, holistic and wraparound approach. And I think, Katie, this is what you're talking about a web. So it means that community legal centres frequently have experts on staff that are social workers or financial counsellors. And you'll also find community legal centres operating all over the place, in hospitals, in schools, in maternal health care centres. And there's even the Expresso legal program where community lawyers have been trained to make a coffee on a coffee machine, and then they visit new developments in isolated communities in a coffee van where there's no or very few existing community services because the areas are just being built up at the time. Community legal centres also provide legal education in their communities and are active in law reform initiatives. So it means we're uniquely placed in that role of providing access to justice for Victorians. It means our services open avenues for legal advice, information, services, representation, regardless of those personal circumstances that can frequently be inhibitors, like low-level English literacy, homelessness, mental health, race, gender, geography. 1/4 of our clients have disabilities, and 7 out of 10 have experienced family violence. 1 in 5 identifies as having mental ill health, and that number rises to 3 in 5 when we're working with clients who present with 6 or more legal issues. So this integrated approach is central to these issues of access to justice. So did you know that research shows that a person is more likely to speak with a doctor about their legal problem than a lawyer? A report in 2021 from Ernst & Young that was looking at our community legal centre integrated services found that if not for community legal centres' free on-site legal services at a suite of hospitals, 40% of the patients who received services would not have gone and seen a lawyer. And the main reasons they gave was cost and accessibility. And obviously you can see that both of these issues are overcome when you integrate the services into the places where people are, and those services are free. So in 2021, we worked with the Victoria Law Foundation to conduct a survey of our workforce. And I'd really like to acknowledge here the work of Dr. Josica Cooten and her team at the VLF, because it's tremendously useful research. It's amazing. And we're producing a series of reports that's coming out of it. 4,000 people now work in Victoria's community legal centres, and about half of them are volunteers. And the survey interrogated a broad range of factors, including one whole section dedicated on legal education and community legal centre workers' experience of their legal education. Now, one of the questions we asked respondents was whether they felt their law degree in particular prepared them for work in community legal centres. And I'm hoping you've got a picture in your head now about the type of work that our community lawyers do. And the answer, whether their law degree prepared them, was a pretty resounding no. 54% said that their law degree in no way or not really prepared them for a career as a community lawyer. Only a small 6% said that the degrees prepared them entirely for their careers focused on access to justice. So this disconnect is really interesting for us to understand and work with the universities to try and find ways that we can find ways forward that mean we don't get those kind of feedback into the future. So this survey has provided us with some tangible feedback from people working at the heart of access to justice on where legal education could be improved to enhance community lawyering. And I look forward to sharing some of those ideas with you as we go through the panel this afternoon.
Thanks, Louisa. That was a really interesting, quite challenging concept that so many law students say that they're not prepared. It's just quite, it's quite a, thanks for shocking me. I just wanted to kind of draw out another question that evolves out of what you guys have actually articulated already. There's a kind of critical perspective that's commonly put out there that that asks us to consider whether, as part of law school and legal education, we're actually part of the structures and barriers to access to justice, or are we working to ameliorate or diffuse those barriers? And I wondered if you had any comment. Perhaps I might start with Anna this time. To what extent is it accurate to say that legal education and the structures within our frameworks here really actually contribute to the barriers rather than, remove them?
Well, I guess I'd start by doubling down on Katie's comments for sure. So won't repeat those points. I guess as you ask the question, the thing that comes up for me is I reflect on, it made me reflect on a common experience that I have, which is that in my role as a clinical law professor, as a teacher in a law school, I often find myself undoing, from my own perception, my own words, undoing damage that happens to students in other contexts in the law school. So we like to say, in experiential education, some folks like to emphasize that we shouldn't put a capital E's in front of those things, because of course we're all learning experientially all of the time, right? So whether we call a course experiential or not, we're training people, right, how to behave and what's expected of them. And in many courses in law school, given the curve and the way that teachers choose to run their courses, what's rewarded is individualized success, competitiveness, winning by being at the top of the heap in grading. And I've chosen to teach in a context where I teach students, where a student wins when their team wins, right? When they achieve something together, and trying to teach and work in those ways, it often feels like I'm undoing things that have been done by the institution that I work for. And I don't have any quick answers to how to solve all of that, but that is a challenge I see. So I guess my answer is, to your question, is yes.
Should never ask a question that could have a yes/no answer. Katie, I feel like you want to add something here.
Well, yeah. Absolutely. Thanks. I suspect we all do. But I'll certainly I'll certainly comment on it. I mean, I think my prior response probably made it clear that I think that, yeah, the current structure of legal education replicates, creates barriers to access to justice. I mean, I think it's hard to argue that it doesn't. I think identifying the barriers is somewhat easier than figuring out how to overcome them. I'll discuss maybe some possible areas for movement, although the kind of structure of legal education has proven intransigent enough over past decades that it's a little hard to muster optimism about where the change would come from. I mean, first we've got law students who lack structural power and are only there for 3 years. At many law schools, every few years you'll get a student group popping out talking about reforming legal education. But they're there for 3 years, right? It's very easy for the administration to wait them out, and then they graduate and become lawyers, and it's sort of in the past. And one way to overcome this, one possible way to overcome the structural barrier, I'm working with one T14 law school right now that's trying to make it happen, is creating a coalition between current students and recent alums. The students I'm working with are doing this largely around wellness, but I think access to justice would be another area where this kind of coalition would be really appropriate. We need people kind of on the other side of law school in organizations with students in law school to think about how to create an impetus for change that administrations might want to listen to. And then we have the law school administrations, right? And to me, this is maybe the least likely source of change, although it's probably the greatest source of power for change. Some law school deans have serious visions about reforming legal education, and a couple even have visions of access to justice, but there are big forces working against change, right? We've got the ABA rules, tradition, risk aversion, the rankings, donations from law firm partners who really like being able to pluck smart people up their 1L year and lock them into a job super early. So, to what extent is there an impetus for real curricular reform? For the most part, law schools hire faculty members who serve the law school's current goals as they exist now, right? Who look like the faculty already there. People who came through and excelled within the very system that is so divorced from access to justice. And we see these hierarchies replicated all the time in law school hiring, which takes us to the faculty. On the faculty side, we've got access to justice research that tends to be marginalized in various ways. It's not high constitutional theory, at least we haven't figured out a way to make it such. And the people who write and think about direct services tend to be hired into what often end up being lower status, lower paid, sometimes not tenured positions, right? Clinicians, legal writing instructors, and almost everyone hired, doctrinal faculty or otherwise, is a lawyer. Why? Why aren't we hiring some non-lawyers, right? Whose primary expertise is maybe understanding distributive inequalities or thinking about how everyday people think about the law or tech innovations or design thinking, right? To the extent that this does happen in law schools, it is rarely or never at the kind of core of the curriculum. Anna talked in her first answer a little bit about how the idea that law schools may be kind of left in the dust if they don't think more carefully about deregulation, and part of me agrees. The other part of me feels like maybe it won't matter as long as there's no major public outcry about access to justice, which there absolutely should be. But I am cautiously optimistic that the Utah model, the Arizona model, and other states that are experimenting with deregulation are going to put enough pressure on law schools that we're going to see some movement. How much, I'm not sure, and what that's going to look like is a very open question.
Thanks, Katie. Jeff, since we're talking about the role of law schools and where breaking down the barriers can be achieved, do you have any reflections on what's been said already and this idea that are we part of the problem or part of the solution?
Thanks, Melissa. I think that law schools, certainly in an Australian context, have seen themselves in a particular way and operated sort of using models of large group teaching, lecture-based work that doesn't situate the client or the possible client at the middle. The focus has been on the law rather than the people. And to me, that's one of the difficulties. The reliance on large group teaching and lecture-based arrangements makes it difficult to include the client in that way. And though that sort of model is reflected in the government funding arrangements that perpetuate themselves. And so I think it takes a brave law school to take a different approach. And that involves regulators recognising the value of a set of teaching methods and student learning methods that, like I say, have the client as a focus. And so there's multidisciplinary dimensions to that, that is service focused. And so the problem or problems that are being solved are the problems of the client, rather than it being simply presented as a legal issue that we need to nut out. Trauma informed, but also we overcome the competitive dimensions, or we counterbalance the competitive dimensions by looking at collaborative arrangements. And so that collaborative focus, I would have thought, is really important. And we also emphasise reflective practices so that students are learning from those experiences that they have, rather than, okay, I've done that, now I'm moving on to the next thing. It's about, how do I take the insights and understandings from what I've just done and make use of them in the future? So I think that, I mean, you can tell that I'm describing a model of ethical clinical practice, which is focused on reflection, and that's a really an antidote to at least some of the concerns that are involved in perpetuating barriers by the very practices that we use.
Thanks, Jeff. That's a very good observation. Louisa, you might have something to add to this discussion, but I also wanted to feed into you a question that's come in the Q&A, which was, do we have a sense of whether the students need more lawyering skills, more what's described as soft skills, more substantive legal knowledge, more community or resource contextual knowledge? So where would you like to see the changes taking place in this domain?
Thanks, Melissa. And I'll speak to what the workforce said in the survey, which is that it's both the technical legal areas that are covered at university. So I don't know about you, but I studied Roman law and I haven't used it much in my workplace. So that technical skills, what are the kind of real world problems that people attending community legal centres have, and having a bit more of a focus on that as being a really valid education pathway, but also very much seeking more skills on dealing with clients. Community legal centres deal with people with complex problems. It takes a lot of skill to deal with people and get the right results for them in that context. I think someone else earlier mentioned just not lawyers dealing with lawyers and having that conversation at that level. We're dealing with people who don't necessarily recognise that the issue they have has a legal solution as well. So definitely about dealing with improving those soft skills. So skills training needs on focusing on working with clients very strongly came through the survey, making education practical and the importance of placements in doing that. So actually getting out and doing some real world experience, what it's like. But one other thing that I think taps into your first question there is about what were some of those things that the barriers and enablers. And one of the things that came out repeatedly in the survey was that specific lecturers inspired an interest in social justice in our workforce. So that absolute personal connection with an educator who makes a student want to pursue a career in social justice. So I think staffing the faculties with a range of staff, including people who are passionate about social justice, is a really big enabler to ensuring access to justice is in the mind of students.
Sorry, thank you. I just lost my mute button there for a second. Thanks for that, Louisa. Jenny in the questions has asked a really good question, I think, for us to consider in this context of legal education, because the mode of legal education that we have focuses on exceptional appeal cases, which are often very obscure or hard issues of doctrine, rather than focusing on everyday legal matters and legal needs of a commonplace nature. Does this create some of the disconnect between legal education and then practice focused on access to justice? Jenny didn't say all of these things. I'm adding a bit of editorializing in here. Thank you, Jenny. So it seems it takes us a while. It takes us a while, and certainly takes students a while to realise who their clients are, and that their clients are not going to be, as I think, as Anna said, constitutional court judges or the Solicitor General per se, but our role as lawyers is going to be in a much more foundational level. So is it something about legal education fundamentally, and that way that all of our jurisdictions tend to focus on the appeal case model of education, that causes this congestion? Anna, did you want to respond to me first?
Sure. I couldn't agree more with sort of this point that the question asker raised. And it is certainly true that legal scholarship and law school, and what we choose to teach in law school, largely focuses on what I often think of as the uncommon and the extraordinary, as opposed to the common and the ordinary. And one reason for this, I think there's a lot we could say about it. One reason is people write about and think about what they know. And law professors in America, speaking for the US context today, go to law school. They might work at a big firm for a little while. But most of them, a core part of their experience is serving as clerks in appellate courts. And so very understandably and rationally, that's what they know, and that's what they want to talk about and write about and think about. The other piece I would add, that I would imagine most people on this panel, if not everyone, would agree with, that's related to this, that we've said out loud, is that law students are taught implicitly and sometimes explicitly that there's only one way to be a lawyer and only one type of lawyer to be. And that is sort of in this appellate model or an affirm model. And we don't actually show students how they could use what they learn in law school or use the law to do all kinds of different things. We really narrow the universe of the possible.
Did anyone else on our panel want to respond to this question? Jeff?
Thanks, Melissa. I think that there are real issues in terms of an over-reliance on appellate decisions. There are lots of, I think in law school, the assumption is that the facts are certain because they're provided on a sheet of paper, but the law is uncertain. Actually, in many, many instances, the law is pretty straightforward or is settled. It's what actually happened that is much more uncertain, needs to be teased out, needs to be understood. I can remember in my PhD research, one of the clinicians that I interviewed, when we talked about the focus of a clinic on those everyday cases, she said, well, the client is the complexity and they are providing that. So it does seem to me that that's important. But of course, there's also room for, in some instances, those appellate cases can be really powerful. I can only refer to the anti-death penalty work that my colleague Sarah Cavall is involved in with her groups of students, together with Jen Paneth and Sally Anderson, and Reprieve Australia, where they are assisting folks on death row in various countries. And to me, that's a powerful area where our students, they're not running those cases on their own, but they are making a powerful contribution to seeking to support those sorts of clients. And there's other examples that I can use of a balance of different types of cases. It's not just casework. It's also about strategic advocacy of many different kinds that can very usefully be either led or contributed to by students working in collaboration with their supervisors, as well as members of the profession, other members of the profession who are bringing their expertise. So in our climate justice clinic, we've got leading members of the bar who are assisting the supervisors of the students, Hubert Alge and Malvina Hagedorn, to work on major strategic litigation. Again, not doing it on their own, but there's a time and a place for that work, just as there is for those everyday cases.
Thanks, Jeff. Katie.
Yeah, I agree with everything that Anna and Jeff have said about this. I wanted to kind of throw two more thoughts into the mix. One is that, I think it's absolutely true that the case method, it in some ways minimizes the fact that all of these cases started as a person with a problem. But what we don't do is start law students' legal education as a person with a problem. And in some ways, I think that if we required, some kind of direct services clinic or something like that from the very beginning of law school, before students really have much formal training at all, we would be able to impart to them actually how legal problems evolve and allow them to have a much more holistic view of even if they are learning with the case method, where cases come from. The other thing is that, we talk a lot, we being legal education, I guess, as about thinking like a lawyer. And when we talk about thinking like a lawyer, we often talk about how we teach law students to think. So, we teach them logic, we teach them to distinguish relevant from irrelevant facts, whatever. But I think that a less good part of teaching students how to think like a lawyer is also teaching them what not to think. And I think that one big problem in legal education is how students are socialized in the classroom to not ask certain questions, right? The student who raises their hand and asks, wait a minute, but wouldn't that appellate decision systematically disadvantage poor people, is going to be frowned at, people are going to chuckle, and the professor's going to move on. And I think that instead of teaching students how not to think, we need to be really curious about, well, why is the student thinking that? And maybe as lawyers, we can't do anything about that, but who might be able to if you had a client come to you with this problem?
Thank you, Katie. But every time you speak, I feel like we need to add another hour onto our session. No, that's called a compliment. That's not a criticism. Louisa, did you want to add anything? I mean, we are heading towards the end of our time, and I did have one little wrap-up question that I wanted to pose to people, but there's been a couple of questions in the Q&A, and I just wanted to sort of summarize them in this way. So we've talked a little bit about the role of the law school, but there's also a couple of questions in there about the role of legal education that follows on from law school, and what it is that we provide our graduates with in the post-law school environment, and the role of the profession itself who hires our graduates, and how we deal with lifelong learning in law and that relationship with access to justice. So I wondered if any of you had closing thoughts on that dimension of it. And Louisa, maybe that is something that feeds into your area and the survey that's been done.
I wondered, Melissa, if I can just read one of the quotes from the survey. So this is what one sort of said about the connection, which is, law degrees are tailored for persons seeking to work in private practice and often with a significant focus on commercial matters. While learning to study the law is obviously important, the practicalities are simply not taught. No universities teach students to review a fine or make an application regarding a tenancy dispute. They don't teach you how to make referrals to non-legal supports for your family violence client. So it's the nature of the legal sector that corporate, commercial and private practices are held in an elite view, and being the only place that you should aspire to work, and that working for even a small regional private practice is somehow less than. And I think that feeds into how we do that in that later study as well. After we leave our undergraduate degree, what position are we in to springboard from that into further study and further opportunities if by that end of that undergraduate, we've already had that influence of a pathway into commercial.
Yeah, I feel really sad that the student or that the lawyer who answered the survey in that way actually feels that, because it really feels like a shallower experience of what they learnt in their law school education or their own education. And I'm sure it's not uniform for all law students, but clearly it's a very, heartfelt sort of view.
And I think though that, it's countered by people who got so much, particularly out of placement programs, and saying that, I took a placement program here. This allowed us to work with clients, manage a few files under supervision, and I think it should be mandatory. A lot of the students who participated in that kind of programming said, that's what I need to know to be a community lawyer.
All right, so I'm going to go to last words or wrap-up statements. Jeff, I'll let you go first in view of what we've just been talking about, and then I'll whip it right round.
Thanks, Melissa. I think that, in terms of post-degree development, we've seen a reduction in the amount of practice emphasis and workplace experience that is involved in that phase, that practical legal training phase. It's a 3-week experience that's required. And so there are certainly questions that we need to ask in regards to whether that needs to be a stronger focus. But as far as law schools are concerned, it seems to me that there's real value in that experiential education. You would expect me to say that, but I really believe it in terms of we can leverage our strengths, we can develop partnerships which enable us to draw on the enthusiasm, expertise and resources of a broad range of interested parties to develop what we do in effective ways. And clearly working with other disciplines, be they within our universities or professionals, paraprofessionals from elsewhere, is going to be really important in providing the wraparound services that Louisa referred to earlier, which I think is a really important part of a rounded, informed legal education.
Thanks, Jeff. Anna?
I'm tempted to yield the balance of my time to Katie Young.
Up to you.
But I'll briefly say this before I do. I have my own dream that relates to this question is I have a vision in my mind of democratizing legal access to legal education. Right now, speaking in the U.S. context, it's held tight in these 3 years in a graduate program, tightly. It exists a little bit in some other spaces, but we hold it tight. As a freshman in college, you could take English Literature 101 or Introduction to Spanish, and test out all manner of different disciplines and fields of understanding, and we don't have that in law. And I think that law is different from other disciplines. We could maybe compare it to medicine and pick on medicine and say that not everybody's gonna in their life might need to, I don't know, stitch a wound, but everyone who lives in a nation state is going to engage with law, right, in some form or fashion. And so that's sort of my dream, that not just on the back end, sort of for continuing education, but much earlier, that we help people understand the rules that govern their lives in a much more accessible and meaningful way.
Thank you, Anna. And Katie, you get to wrap it up.
Yeah. Well, I guess I'll wrap it up with something that maybe previews or opens us to talking about the next session as well, which is a question that Simon asked in the Q&A, which was, do we need a paradigm shift in the way we're framing this issue? Should we be shifting away from thinking about access to justice toward access to problem-solving resources? And I think that's a really interesting question. I mean, a lot of the interventions we're talking about would serve access to justice goals, but things like design thinking and legal consciousness and cultural competence and so on would really serve all lawyers. I'm not sure about whether a paradigm shift in the framing would help this or not. I mean, we might imagine that if it's not pitched as access to justice, it would be less marginalized, right? If law firms thought it was something that would help them. And this is what, I mean, one of the things that I'm hoping the next panel is going to talk about, right? How we can position access to justice in ways that would form broader coalitions. I do think that to be realistic and make change actually happen in ways that's going to be sustainable in law schools as they exist now, we're going to have to figure out a way to plug access to justice into law schools' existing hierarchies and make it an area that people with power really care about.
Good moment to go. Good moment to remind people the next session is starting in 5 minutes. I've run over my time by 3 minutes, which is an excellent version of my record of not running over time. What I mean is, if I've only run over 3 minutes, that's pretty good for me. So I want to thank all of our terrific panelists for their stimulating provocations, left us with lots to think about. We're probably going to have to all catch up separately another time and finish our conversation properly. But I want to thank also the audience here today who have joined us and been part of this magnificent process of this 3-day exploration of these issues. And I'll see you in the next session. Thank you, Hugh, and thank you to the technical back of house people at the Victorian Law Foundation.
Yeah, I just want to jump in and quickly reiterate all those thanks. I hope everyone who was able to attend could see the description of the panel as going to be such a stellar one. Is such an important issue, the connection between law school education, access to justice, or access to problem solving. I hope everyone can hang around for the final session. I'd like to thank everyone. Say goodbye.